All right, good evening, everyone. For those of you who do not know, my name is Matt Green. I'm president of our local Federalist Society chapter, the Brevard and Alex Howard chapter of the local Federalist Society. We are excited to host Darpana Chef tonight with the Institute for Justice. She is actually the second attorney from the Institute for Justice we had. Our first one was Mark Neely for many years in Nevada, one of our best speakers. We wanted to go back to the well, and I know Darpana's going to be very excited tonight. We're going to be very excited tonight to have her. For the video, the Federalist Society is a nonpartisan, conservative and libertarian organization dedicated to freedom, federalism, and judicial restraint. The Federalist Society seeks to promote and educate the legal community and its lay citizens through its programs and publications about how limited constitutional government, based on the rule of law, it has a positive effect on law and public policy. It's founded on the principles that the state exists to preserve freedom, that the separation of government powers is essential to that freedom and to our Constitution, and it is emphatically the duty and province of the judiciary to say what the law is, not what it should be. Tonight, our topic will be on civil asset forfeiture, and for those of you who are not familiar with it, and to be honest with you, I didn't become really familiar with it until the last year or so. It's really shocking, some of the stories you're going to hear tonight that happen here in this country. For those of you who do not know, civil asset forfeiture involves the government seizing property of citizens without charging them for a crime. It's an upside-down world where the innocent owners have to prove their innocence, where normal constitutional guarantees of due process really don't come into play, because it's a civil action, and the burden would be, in many instances, on the innocent owner. Many of the times the property is seized, whether it be real estate, personal property, cars. When it's seized, the value of hiring an attorney becomes cost prohibitive. Those who are oftentimes victims of civil asset forfeiture don't have money to retain or hire an attorney, and oftentimes to do so would be more than the property's worth, which is, I think, is probably one reason why we don't see a lot we don't hear a lot about it in the news in our area yet. Anyway, there are also fundamental concerns with federalism. And when I say that, I mean when a state makes a policy choice that legislatively passes legislation that protects property rights, and it becomes a public policy of the state to protect those property rights. Civil asset forfeiture allows law enforcement and the government to circumvent that. And the programs you'll hear tonight have concepts called adoptive forfeiture and equitable sharing. The money, the property is seized by the government, and for some reason or another, most oftentimes where the state laws are not conducive to the forfeiture and are in fact illegal or unlawful under state law, the forfeiture will be then turned over to the federal authorities in a much more lenient scheme, and it's much more conducive and much more anti-property. There's also serious concerns constitutionally speaking with the immense power it now gives the executive. And Darpana probably talked about this in the Appropriations Clause under Article 1, Section 9, Clause 7 of the United States Constitution. Congress has the power of the purse. It's a significant power. It's a check on the power of the executive. Well, under this civil asset forfeiture, the executive, law enforcement, and the government is allowed to amass extremely unchecked power and property, and oftentimes without public disclosure. And in fact, if you look, the Institute for Justice has given a score sheet that you did every state, I believe, and I included Alabama in your handout. The state of Alabama does not require public disclosure. That's one of the things that's made it very difficult to monitor in terms of due process and the nature of the seizure and whether it's compliant with due process. But Congress is supposed to be the final arbiter of public funds. When the executive no longer has to answer to Congress, they can create their own powerful branch that it really makes it very difficult for Congress to reel them in, and they don't have to abide by the rules. They have unlimited, in many instances, unlimited assets, and it only gets more and more and more. And in many instances, it's become a stable part of the line item budget for many of the government, of the prosecution and of prosecutors. So it's a dagger in the heart, I think, in many ways, to federalism and to the separation of powers scheme that our forefathers saw fit to pass. There's no oversight. You'll hear words like and phrases in government policies, what we call structuring. And you'll probably talk about that tonight, I'm sure. Policing for profit. And perhaps, and one last thing, and I'll it oftentimes results in over-policing. Police or law enforcement will focus on profit, where the money is, and oftentimes at the expense of other serious violent felony cases. And that's just human nature. That they go to where the money will be, where it's most profitable, where they look to seize more money, and oftentimes, as I said, that'll be at the expense of prosecution of violent crimes, where traditionally you would think your local law enforcement or federal law enforcement should be geared towards. But anyway, let me tell you a little about Dorpana. She is with the Institute for Justice. It's a public interest law firm. They are the guardians of liberty. They take on cases for those who really don't have the money or the resources to fight the government when they take their property. They litigate a lot of economic liberty cases, and they've been very good with that. Ms. Sheff litigates cases on economic liberty. She was part of the trial team, actually, that was essential in striking down Louisiana's government-imposed monopoly on the sale of caskets. She is currently is a lead attorney in the federal civil class action case against the city of Philadelphia. I don't know if y'all been following that. It's a pretty pernicious property. They seize his property without due process, and it's really drawing attention, thanks to Institute for Justice, liberty-loving people.
Matt, what's pernicious mean?
Wicked.
Oh, okay.
It's common law. She received her degree from Georgetown University. She was at one time was assistant attorney general for the state of New York. She litigates. She's an associate also at the Manhattan law firm of Chapel and Parks and Rec. She was a former law clerk to Judge Jerome Holmes in the Circuit Court of Appeals, 10th Circuit. She's recently, within the past February, I think, she testified before the United States House Committee on the Judiciary and U.S. Senate Judiciary Committee. She is one of the foremost legal authorities in the civil asset forfeiture, so we are very lucky and excited to host her. So please join me in welcoming Dorpana Sheff.
Well, thank you so much for having me. It's really a pleasure to be here in Mobile, Alabama. I have not been to Mobile before, but thank you so much to the Federalist Society chapter for hosting me on this very important and timely topic. I'm sure a lot of you have been hearing about forfeiture in the news recently. So what is civil forfeiture? Civil forfeiture is one of the greatest threats to property rights and due process in our nation today. This controversial law enforcement tool not only strips people of their property and their due process rights, but it also undermines the public trust that we have in law enforcement and the belief that's so vital to our republic, that we're a nation ruled by laws and not by men. So what is civil forfeiture? To borrow comedian commentator John Oliver's line, it sounds like a Gwyneth Paltrow euphemism for divorce. I see we have a lot of people standing. If you want, feel free to come up and... So civil forfeiture is the government's power to confiscate property that's suspected of being involved in a crime. Unlike criminal forfeiture, which requires a conviction, civil forfeiture permits the government to take property regardless of the owner's guilt or innocence. Now, civil forfeiture has become easy fodder for comedians like John Oliver or Jon Stewart. Even former DOJ officials, such as John Yoder and Brad Cates, though, who were involved in creating the current federal forfeiture regime, have called for it to be abolished, acknowledging that forfeiture has, quote, turned into an evil itself, with the corruption it engendered among government and law enforcement coming to clearly outweigh any benefits. Today, 60 editorial boards and counting from outlets as diverse as the Wall Street Journal and the Washington Post have criticized civil forfeiture. It's produced a hard-hitting series of investigative pieces in major outlets like The New Yorker, and the New York Times exposed the federal government's aggressive use of civil forfeiture to seize bank accounts from small business owners and individuals who were never charged with any crime. And in its Stop and Seize series, the Washington Post told an almost unimaginable tale about how state and local police have seized over $2.5 billion in almost 62,000 highway interdictions since 9/11, all without any warrants or indictments. And speaking of the unimaginable, civil forfeiture has caused lawmakers from both sides of the aisle, in state houses across the country and even in the houses of Congress, to actually agree on something. So how did we get here? Civil forfeiture is based on the legal fiction that property itself is guilty. Under this fiction, the proceeding is brought, quote, in rem against the property, not in personam against the owner. And that's why these kind of cases have unusual names like United States versus 434 Main Street, Tewksbury, Massachusetts, a case I was very proud to work on. Or Commonwealth of Pennsylvania versus $520 in US currency, another IJ case I worked on. Or US versus approximately 64,695 pounds of shark fins. That is not a case I got to work on, unfortunately. Of course, objects such as property, cars, cash, or even shark fins do not act or think and can't really be guilty. The doctrine of in rem forfeiture originally arose from the medieval law of deodand, under which chattel that caused death was forfeit to the king. Now, deodand is premised on the superstitious belief that objects acted independently to cause death. In the United States, civil forfeiture traces its roots to the English Navigation Acts of the mid-17th century. And these acts required imports and exports from England to be carried on British ships. If the acts were violated, the ships and the cargo on board could be seized and forfeited to the crown, regardless of the guilt or innocence of the owner. Using these navigation acts as a model, the first US Congress passed civil forfeiture statutes to aid in the collection of customs duties. At the time, these customs duties provided 80 to 90% of the finances for our fledgling federal government. Now, this power was upheld in early Supreme Court cases, but the most important aspect of these early cases is the very limited justification for civil forfeiture. The Supreme Court held that civil forfeiture was closely tied to the practical necessity of enforcing admiralty, piracy, and custom laws. In rem forfeiture permitted courts to obtain jurisdiction over property when the guilty property owner was either overseas and so couldn't be hauled into court. With civil forfeiture, the government could ensure that customs and other laws were enforced even if the owner of the property was outside the court's jurisdiction. Although the Supreme Court had permitted the government to expand the forfeiture power during the Civil War, throughout most of the 20th century, civil forfeiture remained a relative backwater in American law, with one exception, and that was during Prohibition. Civil forfeiture was used to seize automobiles and other vehicles that transported illegal liquor. Unmoored from this original justification of jurisdictional necessity, modern civil forfeiture laws in the early 1980s exploded as government at all levels stepped up the war on drugs. Because civil forfeiture laws differ across jurisdictions, I'm going to focus on the two key problems with civil forfeiture laws today. First, the poor protections for property owners, and second, the direct financial incentive underlying most forfeiture laws. As a civil proceeding, property owners contesting civil forfeiture do not enjoy the constitutional protections that are afforded to criminal defendants, like the right to counsel or the right to a prompt hearing. Additionally, it's easier for the government to forfeit property through civil forfeiture than through criminal forfeiture in two key ways. First, the government enjoys a lower burden of proof than in the criminal context. Today, in most states and under federal law, the government must only prove by a preponderance of the evidence that the property was used in or as proceeds of a crime. Now, this is obviously lower, significantly lower, than the beyond a reasonable doubt standard that's required for criminal convictions. And in Alabama, the standard is even lower. The government only needs to present a, quote, prima facie case that the property is related to criminal activity and therefore subject to forfeiture. Second, after the government meets its burden to show property is subject to forfeiture, in 38 states and including Alabama, as well as the federal government, the burden shifts to the property owner to prove his innocence. This effectively turns the idea that you are innocent until proven guilty, a hallmark of the American justice system, on its head. In light of these evidentiary burdens, which stack the deck against property owners, it is no surprise that law enforcement pursues the easier avenue of civil forfeiture rather than the more difficult avenue of criminal forfeiture. Indeed, studies have shown that when the law makes forfeiture easier for the government to pursue through lower standards of proof, law enforcement officials will engage in more of it. But there's another reason why law enforcement makes heavy use of civil forfeiture. In most states and under federal law enforcement agencies are permitted to keep all or at least a significant portion of the proceeds from the property they forfeit. Indeed, here's how one local police chief in Missouri characterized civil forfeiture.
There's some limitations on it. You know, it's actually there's not really on the forfeiture stuff. We just usually base it on something that would be nice to have that we can't get in the budget for instance. So, you know, we try not to use it for things that we need to depend on, you know, because we need to go ahead and have those purchased. But it's kind of like pennies from heaven, you know, it gets you a toy or something that you need, is the way we typically look at it.
Pennies from heaven. In 26 states, including Alabama, and the federal government, law enforcement agencies are entitled to keep 100% of forfeiture proceeds. At the federal level, forfeiture has grown exponentially. In 1986, the year after the Department of Justice's Asset Forfeiture Fund was created, it took in just $93.7 million in deposits. 20 years later, annual deposits of forfeited cash and property regularly topped $1 billion. And 2014 saw an intake of $4.4 billion, the highest amount in the fund's history. The fund's net assets, or money available for law enforcement purposes, has likewise grown from about $500 million in 2000 to $1.8 billion in 2013. At a time when government at all levels face serious budgetary limitations, it's not surprising that law enforcement officers are ever more attracted to civil forfeiture, even law enforcement officials with the best of intentions. But by creating self-financing agencies, civil forfeiture laws violate the separation of powers. George Mason warned about the dangers of combining the power to execute laws with the power of the purse. But that is precisely what modern civil forfeiture laws do. Here, the same law enforcement agencies that seize and then file suit against the property keeps that property and then decides either to keep it or either how to use it or spend its proceeds. What is lacking is the crucial oversight that's provided by the legislative branch and the appropriations process. Worse, under a federal program called equitable sharing, state and local law enforcement can seize property for a federal forfeiture action and in exchange keep up to 80% of the proceeds. Now, members of this audience will appreciate the federalism problems raised by this form of legalized bounty hunting. Even where a state's law provides greater protections for property, state and local law enforcement can simply evade those laws by referring forfeitures to the federal government. And Alabama is no exception. Law enforcement agencies in Alabama have received more than $68 million just in equitable sharing payments since 2004. Now, on January 16th, then Attorney General Holder announced a new policy prohibiting certain kinds of adoptive seizures under the federal equitable sharing program. Adoptive seizures are, or adoptions as they're called, are where state and local law enforcement can seize property under state law and then simply refer that to federal authorities to pursue a federal forfeiture action. And that federal forfeiture action doesn't need to be in court necessarily. There's a lot of administrative forfeiture actions. Now, contrary to some exaggerated media reports, the new policy does not end civil forfeiture. Federal and state government can still take property for civil forfeiture without even charging, much less convicting owners of a crime. And the policy also does not abolish the equitable sharing program. Seizures under joint task forces or coordinated federal and state investigations are still allowed, and this includes many of the drug task forces that conduct highway interdictions in so-called high-incident drug trafficking areas, which were exposed by the Washington Post in its story. According to a GAO report, 83% of equitable sharing cases in 2012 were from joint task forces, with only 17% from adoptions. And from 2008 to 2013, adoptions made up only a quarter of all equitable sharing cases. Indeed, the Justice Department itself has acknowledged the limited reach of its own policy change, noting that adoptions only accounted for 3% of the value of assets seized in the last 6 years. So you've heard of the horror stories of forfeiture slush funds. A subsequent policy directive attempts to clarify what constitutes joint investigations, but it provides only a vague standard of requiring sufficient federal involvement and leaves line prosecutors and agency counsel with much discretion. The policy also does not cover seizures if there is a federal seizure warrant. Federal authorities can simply adopt the seizure if they get a magistrate judge to sign a seizure warrant, even if there is insufficient federal participation. And getting a federal seizure warrant is easy. These are, of course, done ex parte, which means without notice or a hearing, and with a one-sided presentation of evidence. In fact, IJ has successfully defended 5 small business owners who have had their bank accounts seized for structuring violations pursuant to ex parte federal seizure warrants, even though there was no allegation of any other crime. No allegation of money laundering, terrorism financing, or drug crimes. Finally, even within adoptions, the policy carves out an exception for public safety, listing 4 non-exhaustive categories, including firearms, ammunitions, explosives, and property related to child pornography. It remains to be seen whether this public safety exception will swallow the rule, though, because the criminal assistant attorney general can approve any adoption even outside of those 4 categories. And these public safety categories also seem unnecessary because to the extent these items constitute contraband, they could be seized anyway. So the relative ease of taking property under the procedures, combined with the financial incentive to do so, creates a toxic mix that has led to abuse. And the stories of abuse are ubiquitous. You've heard of stories of forfeiture slush funds used to buy margarita machines, Zambonis, Segways, and trips to Disney World. And you've probably heard of a number of victim stories. I'll give you one from your own backyard. Ming Tung Liu, a 55-year-old Chinese-American restaurateur from Georgia, was pulled over on I-10 by a Mobile County Sheriff's deputy for going 10 miles over the speed limit. He was carrying $75,000 in cash raised from investors and relatives to buy a Chinese restaurant from over in Lake Charles, Louisiana. The deputy asked for permission to search the car and seize the money. Law enforcement detained Liu for over 2 hours. According to his attorney, Liu doesn't even speak English and didn't understand what the police said. He eventually got his money back 10 months later after documenting the source of the funds, but only after spending thousands of dollars on a lawyer and losing out on the restaurant deal. Now, the problem with civil forfeiture laws is not just a few bad apples making questionable purchases with an unaccountable stream of revenue, or being overly aggressive in seizing property. It is fundamentally a problem of a bad law that systematically incentivizes bad behavior. Defenders will argue that civil forfeiture laws create a win-win where criminals lose and the public wins as more resources are available for law enforcement to fight more and more crime. But a recent IJ study puts the lie to this claim, concluding that civil forfeiture encourages choices by law enforcement that leave the public worse off. In other words, as the authors of the study succinctly put it, it's not the players, but the game itself. When civil forfeiture puts people in a position to choose between benefiting themselves or the overall public, people, understandably, choose themselves. And this has been demonstrated in the patrolling of our interstates. As Matt mentioned, police will often over-enforce the side of the highway where money is flowing and under-enforce the side of the highway where drugs are flowing. A Tennessee News investigation revealed that Drug Task Force officers were 10 times more likely to patrol the westbound lanes of I-40, where couriers returned with the money, than the eastbound lanes bringing drugs into Nashville. Ultimately, civil forfeiture undermines the public trust in law enforcement and the rule of law. Something has gone horribly wrong when American public is afraid of carrying any significant sum of money, not because they're worried about robbers, but because they're afraid of the cops who will simply take it. The public perceives police acting like pirates, privateers, and bounty hunters. And because of this direct financial incentive, civil forfeiture has become a, quote, license to steal, and led to the distortion of policing from the pursuit of justice to the pursuit of profit. And this kind of rhetoric is not just coming from liberals and libertarians. A Pennsylvania conservative judge went so far as to call civil forfeiture nothing more than, quote, state-sanctioned theft. Now, the stated rationale for civil forfeiture is to take the profit out of crime. Indeed, that is the motto of the DOJ's asset forfeiture program and how Attorney General Lynch defended the program in her confirmation hearings. Law enforcement justifies civil forfeiture on the grounds that it allows them to stop the bad guys from committing and profiting from crime. But the reality is that civil forfeiture isn't being overwhelmingly used to catch the Walter and Skylar Whites of this country. Here are the real faces of forfeiture abuse. Now, you've probably heard of the class action lawsuit against the city of Philadelphia and the DA's office. My clients, Chris and Markella Suravelis, in the bottom right. Oh, that's right here. Here we go. They stood to lose their entire home, even though they did nothing wrong. Russ Caswell owned a family-run motel up in Tewksbury, Massachusetts, that provided budget accommodations, no-frills accommodations. And over 20 years, a handful of its guests were arrested for drug crimes, all without Russ's or his employees' knowledge until after the fact. Similar arrests were made at other local businesses, including the Motel 6 down the street. There was no allegation that the Caswells or any of their employees had committed any crime, but the U.S. Attorney's Office in Massachusetts singled out the mortgage-free $1.5 million Motel Caswell for civil forfeiture. And it took more than 5 years before Russ Caswell had his day in court, and only then, with the assistance of pro bono help from IJ, ultimately defeated the forfeiture action. Most recently, Charles Clark, who's a 24-year-old college student in Orlando, had $11,000 seized at the Cincinnati Northern Kentucky International Airport. That is IJ's most recent case, and I'm proud to be a part of that now. It's been pending. The federal government filed a forfeiture action last April, and we've now intervened to help defend him and get his money back. The time has come to simply end civil forfeiture and replace it with criminal forfeiture. No one in America should lose their property without being convicted of a crime. Now, short of eliminating civil forfeiture, the following 7 reforms would go a long way to curbing abuse. First, we need to eliminate the profit incentive. Forfeiture proceeds should be placed in a general or revenue-neutral fund. This could be a victim fund or various other neutral funds, but law enforcement agencies should not be directly benefiting from forfeiture proceeds. Second, we need to abolish the equitable sharing program at the federal level. And at the state level, we need to prohibit the ability of state and local law enforcement to participate in the program. And that's exactly what New Mexico recently did in its reform measure that it passed. Third, we need to increase the burden of proof on the government to at least a clear and convincing standard. That's the highest standard in civil proceedings. Fourth, we need to restore the presumption of innocence and require that the government prove that the property owner had actual knowledge or consented to the underlying criminal activity. There would still be an innocent owner defense in which the owner could prove that despite his knowledge, he took all reasonable steps under the circumstances to prevent the illegal use of his property. Fifth, we need to provide a prompt hearing at which property owners can contest the basis for the seizure or deprivation of their property, and federal courts have actually ruled that this is required by due process. Sixth, we need greater transparency. We need to require reporting on how much forfeiture is used and how money is spent. And as Matt mentioned, Alabama has not good reporting requirements, which prevents the Institute for Justice and other organizations from collecting the data to see how forfeiture is actually being used in the state. And finally, we should provide for counsel. Often, the property at stake is worth much less than the amount it would take in legal fees to get the property back. So as a former Assistant Attorney General for the state of New York, I appreciate the difficult job that those in law enforcement have. But all of us in this room also care about protecting property rights and protecting the rule of law. And we can all agree that the goals of law enforcement cannot and should not trump our commitment to either of those or the Constitution above all. I'd definitely love to take questions.
Thank you.
In the area of government doublespeak, which I assume you know a little bit about, assuming you had a condemnation forfeiture case and you raised this small issue about the Fifth Amendment, small little statement in there, but not taking property without due process of law, what do they say? Does some kind of double talk you get back? Or what is the technical response that you get if you raise, you shouldn't take my property without due process of law, because it's in the Fifth Amendment, we adopted the Bill of Rights. Don't I get that?
So I guess there are two questions. One is the Fifth Amendment, you can't take my property, the takings clause. And the Supreme Court and a lot of courts have held that civil forfeiture doesn't apply there because, right, it doesn't apply there because it's taking property for public use without just compensation. It's taking contraband. And you have no personal, right, and you have no property right in contraband. But then for due process, that's primarily the reason that we say challenge civil forfeiture laws on Fifth Amendment at the federal level or 14th Amendment grounds, saying that this is a violation of due process. It's a violation of due process to have to not have an impartial arbiter of your claims where the prosecutor is the one who gets to benefit from the outcome of the forfeiture proceeding. It's a violation of due process to have like a double negative, an affirmative burden to prove that you did not know about something. That's a violation of due process. So these are all different areas that we're challenging at IJ. I'm sorry, yes?
Doesn't the forfeiture legislation that preceded statutes we have now existed before the Fifth Amendment? They were doing these civil forfeitures back before there was a Congress.
Well, yes, and they were in England, of course, they were doing them, and they were using that law of Deodan. At the time of the Constitution and the founding, they were doing it pursuant to, the British Navigation Act.
Justice Story said, right? It was
right.
limited to the
right, to the practical necessities of enforcing jurisdiction. So,
in very limited circumstances.
Right.
But it really shifts the burden to the person that's claiming that the money that they're taking from me was earned legally.
And that's your burden to prove that the money, yeah, right.
That's what the whole thing.
Exactly. And those are the two things that IJ is focused on challenging, both that flipping of the presumption of innocence and the profit incentive, so financially benefiting from it.
Because it's civil, do other ways of protecting assets, such as a trust, protect from civil forfeiture?
No. So both the criminal and the civil forfeitures, let's see, there's something called the relation back doctrine. So eventually, if the government wins and is able to forfeit your money or your whatever property, there's a relation back doctrine which says that the title to that property goes back and vests at the time of the seizure. So it doesn't matter who, if there's a transfer of ownership in between, the government has the property starting from the time it was seized, because that's the starting point. One of the worst cases that came out recently is, and this was in the criminal context, it's a United States versus Cayley, and there was a husband and wife who were charged with stolen property through interstate commerce. It was basically, they were a pharmaceutical team and they were taking medical devices. They were pharmaceutical reps and medical device reps for Johnson & Johnson, and they would sell these devices to the hospitals, and sometimes the hospitals didn't want to buy it, and so they'd have this overstock. And so the Cayleys thought, well, why don't we just resell these and earn some money? And the Johnson & Johnson company didn't want to take them back. So they were charged with stealing property in interstate commerce, and they wanted to hire an attorney, and the government put a pretrial restraint on their assets, so $500,000 against their assets, before trial. So they were indicted, but they were never tried and never had any kind of formal hearing before the court. And the Supreme Court said, even though that the Cayleys needed that money to pay for counsel, that was okay, because they did have a grand jury indictment and they were not entitled to an opportunity to go to court and just contest the basis of that seizure, that this money was earned legitimately, and that they didn't actually steal anything because there was no victim of the theft. Like Johnson & Johnson wasn't claiming that it lost anything. So there's a lot of abuses going on at different levels.
The case of the couple that had the motel you were mentioning, since in that case there were apparently actual criminal activity at the motel, what did you have to establish on their behalf to defeat that in terms of those facts? What did they have to, how did they meet that burden?
So the first aspect was the government has the burden to show that there's a substantial connection, because it was a federal case, between the motel and those drug crimes that they were bringing up. And so a handful of drug crimes in over 20 years. And believe it or not, the case law was pretty bad on that and said, if the property is somehow involved in the crime, then that could be a substantial connection. So that was a tough hurdle to overcome, but we were able to do that in trial and say, that's just kind of fortuitous. It's not like the Caswells were using that property to commit the crime. It's these third parties who have no connection to the Caswells or the employees or the motel. So we were able to eventually win at trial on that first issue of whether the motel was even forfeitable. And then the court went on to even address the innocent owner claim, and that only comes in after you show forfeitability. And there, of course, Russ Caswell was an innocent owner beyond all question. I mean, he did not know about these crimes. Moreover, he would allow law enforcement and police officers to do stakeouts and sting operations and give them free rooms. So he was always cooperating with law enforcement.
The theory was, the government was really that the hotel was the location of drug deals?
That's right. And the judge rightly called them out on it and said, well, that means that in the Walmart across the street, if there's a drug deal that happens there, you can seize the entire Walmart or the Dunkin' Donuts, and the government actually said yes. So it shows, the aggressiveness with which they pursue civil forfeiture.
What are the rights of a lien holder if there's a vehicle used in a drug deal?
So it's the same as the innocent owner. They can also make that kind of claim. Just like an innocent owner claim, lien holders and people, like third parties with legitimate rights and interests in the property, can make a similar claim. But the burden's on them.
Do they have to sue the lien holder as well?
No,
Or
because,
that certain lien holder? Yeah, that's part of it, you gotta serve them.
right, they'd have to serve them. So the lien holder would have to intervene as a claimant and make an actual claim for the property.
That's serve them too.
Is this the same thing that happened to, like Gibson guitars when, a couple years ago? Where
Yes.
their guitars were taken because supposedly the wood they used was illegal?
Right, and that was a civil forfeiture action based on
I'm
the,
not sure if they ever got them back. I don't
no, I think that was it. And that was, I forget the amount, but I remember it being a very high figure of the value of the guitars.
came in and took 'em.
Yeah, yeah.
Arpano, are there any cases, I'm sorry, go ahead. Cindy, I'm sorry to interrupt you, go ahead. Okay. Are there any cases where during the course of litigation, the government starts to realize that it's not so, this case isn't such a good idea, and they enter into negotiation, settlement talks with you, and as part of a proposed agreement, they ask your client to enter into a non-disclosure agreement? First of all, do they do that? Secondly, can they do that? Third, is it ethical?
There's all sorts of shenanigans that go on that front. I think you might have heard the situation, starting with the beginning in Tanaha, Texas, where they will pull aside people, and if the property owner, the driver, doesn't consent to either searching the car or turning over the property and just letting everything go, they will threaten to file criminal charges even though they don't have a basis to do so. So that's kind of at the front end. Then during negotiation, or during the actual forfeiture part, we've seen a lot of cases, especially in the structuring context, where the government takes or seizes bank accounts from small business owners, and then when IJ intervenes, they'll be like, oh, no, well, let's strike a deal here, we'll give it back. And part of it is under a non-disclosure, but of course we fight back on that very hard. So it doesn't happen in our cases, but it definitely happens in other cases.
When they seize the property too, oftentimes they have them sign a waiver, right?
Right.
Threaten them with, after they detain them and question them for hours.
That they will not sue the government for, like, under 1983 or whatever else. So there's a lot of that.
I mean, I'm sure that's a defense if they, one of them was like a waiver. I've seen that the federal government will say, well, no, he has no standing. He waived the rights to this property when he signed this.
Right. And some of those we've seen executed with people like Lou, who don't speak English, or English is their second language, so that's questionable. Philadelphia is probably one of the worst examples of that, where they are kicking people out of their homes, or at least they were kicking people out of their homes until we filed the lawsuit, without any notice, without any hearing, and without what the Supreme Court has said is required is exigent circumstances, because it's real property. It's a house, it's a business, it's not going to run away and go somewhere, so there's no reason to seize it without giving notice. As part of that, the Philadelphia DA's office has been first seizing the home under an ex parte process, and then negotiating with property owners who are not represented by counsel and say, well, if you want to get back into your home, you have to waive all these rights. You have to bar a specific person from ever entering your home, and that happened with our clients, Chris and Marcella Sudaravelis. The basis of the forfeiture was that their son, like 22 years old, had sold drugs, $40 worth of drugs outside the home, and they came after trying to seize the entire home. They evicted them from their home, kicked them out of their house for a week without any notice or hearing, and said, if you want to be let back in, your son is not allowed back in. And so it was 6 months where the son was not allowed into the home. And so it's what we call an unconstitutional condition, and we've been challenging it under that. There are also sorts of waive your rights to assert an innocent owner defense, not only in that forfeiture action, but in any future action. So on facts unknown, you could not bring an innocent owner defense.
Who's
So.
up DA related to the Baltimore DA?
Good question.
Is there any way for the property owner to sort of short-circuit the process by getting an injunction against the government to say, no, until this is solved, until we actually get to go through this process that you described, we get to keep the use of our property?
No, well, at this time, no, in most states and at the federal government, but that's something that we're working to litigate, because what you're describing there is the due process clause, that you have to have notice and opportunity to be heard before even a temporary deprivation of your property. So if you want to use your car to get to work, and meanwhile the government has your car, you can't wait months or years before the forfeiture trial itself. So our argument is that due process requires a prompt preliminary hearing, kind of like when you're arrested, you get a probable cause hearing. If your property is arrested, your property should get a probable cause hearing. And there are a few jurisdictions that have adopted that. In the Southern District of New York, the district court in DC, and that's something that we're trying to either create a circuit split on and take it to the Supreme Court. A couple years ago, the Supreme Court granted cert in a case that presented that precise issue called Alvarez v. Smith. Unfortunately, it ended up being dismissed on mootness grounds because the property owners received their car back before it went all the way to the Supreme Court. So that is definitely one of our litigation goals.
Not to be giving the government any ideas, but have we seen this be applied to intellectual property yet?
Yes.
So my thought is, if I have a patent on some piece of tobacco paraphernalia that could easily be used to smoke marijuana, can the government come in and take my patent?
So we've seen a lot of cases, not just in the patent context, but there was a lot of domain seizures, so the government shutting people's websites down. Perhaps the most notorious or infamous case that's going on right now is the mega upload case, if you've heard of that, in the Fourth Circuit. It's a little complicated, but it's the government pursued a very aggressive interpretation of copyright infringement, and it is a criminal matter though, and so indicted various individuals for copyright infringement for a peer-to-peer sharing network that's all involving the cloud. And the government's theory is that if you provide the service that other people can directly infringe on copyright, then you're also liable. So it's kind of a secondary copyright infringement claim, or I'm not familiar too much with IP law, but something kind of along those lines. And the district court, first of all the property is overseas, and all of the property owners are all also overseas, and only one of them has even been in the United States before. And the district court, and it's now on appeal in the Fourth Circuit, said, one, we're going to claim we have jurisdiction over all this property, even though it's all overseas. So it's an in rem action, and you have to have jurisdiction over the res, but the thing itself, is overseas. And secondly, we're going to treat all these people as fugitives because we're demanding that they come here into the US and defend against this action, and they're still overseas and they won't come here. And so under this doctrine called fugitive disentitlement, we're going to strike the claim they made for their property, and so they won't even ever get a notice or hearing. And so that's now on appeal before the Fourth Circuit, and we're looking into filing an amicus brief in that case.
So even seize your site, like let's say you have a website and you link to a peer-to-peer file sharing, that would seize your site because you have a link to it, and you would never get it back.
And because we don't focus on IP as much, we didn't get involved in that, but there are serious due process issues there because when they seize people's websites, they just shut it down and there's no notice or any hearing involved. I forget the name of the...
Whoever you bought the domain from, they tell them, hey, we're taking this site, the government doesn't, you don't get it back. I mean, you have the server and everything, but the actual...
If you click on the website, it'll say something like this little, this domain has been seized by the, whoever it is.
Somebody could have posted the link in a comment section.
Right. Right.
You're not even the poster.
Right.
What about, and other than due process, of any other arguments like the appropriations clause or federal separation of powers? Are any of the circuits case law on that?
So the appropriations clause is a very novel claim, and we haven't litigated it yet, although the recent case I mentioned about in Kentucky with the airport seizure, we asserted it as an affirmative defense. So hopefully we'll be able to litigate that, but usually the court's going to most likely decide on statutory grounds, like is this property forfeitable? Is there a substantial connection between the crime and the property? And if we win on that, the court will never address the constitutional. But we did raise it, and one day we would like to actually litigate it, because although there's not a lot of great case law on it, I think from a textual standpoint and from the originalist standpoint of what the appropriations clause was meant to guard against, this is it. You know, there should not be self-financing agencies. Congress is the one, the most representative branch of the government that's directly responsible to the people, is the one that decides how to spend the money. And if we don't like how they're spending the money, we can vote them out. If we don't like how the DOJ is spending the money, what do? And there have been abuses at the Department of Justice precisely because of this. One example is this Thompson prison deal. So a couple of years ago, the Obama administration and the Justice Department was trying to buy a prison in Illinois called the Thompson Prison, and primarily to house detainees from Guantanamo when they were looking to shut Guantanamo down. And I don't know if you guys have heard of this, but eventually, you know, Congress, a lot of the Republicans said, no, we don't like this idea at all, and they eventually won and said, you know, and the vote said, no, you cannot we're not going to appropriate funding to buy the prison. And the Obama administration and its Justice Department simply used asset forfeiture funds to do so. So there's like a real, and it's, you know, forget even the politics of it, it goes both ways.
George Mason won against it.
Yep, exactly. So there's other challenges. There's like Eighth Amendment challenges, but the problem with those are they come at the way end. So first you have forfeitability, then you have innocent owner. Only if your property is forfeited do you even get to make some kind of claim that, okay, you can't seize my entire house because there was $40 worth of drugs in the house. So those are kind of few and far between.
Any other questions? One more.
I don't want to dominate, but nobody else. I assume that there probably is a web of laws that, or various statutes that say civil forfeiture is allowable, et cetera, et cetera. Is there one single federal law that if you repealed it, it would sort of start to unravel the rest?
That's a great question. Unfortunately, no. There are over 400 federal laws that allow for civil forfeiture. So you can see how it's like completely expanded. Since the early days, it's expanded in scope in terms of the number of crimes. It's expanded because of the equitable sharing program. So now you have these state and local law enforcement. At the time when equitable sharing was introduced, states didn't have their own civil forfeiture laws, and that's why they provided for equitable sharing. Now you've got all these state laws. So, and it's also expanded.
Is there one that the others are based on? Or?
There is a main procedural statute. So right now, I've been heavily involved with trying to reform like these efforts in Congress and what the different laws we'd need to amend. For example, there is the FAIR Act that was introduced by Senator Rand Paul of Kentucky. And there's a companion bill in the House, and that's very comprehensive reform that includes a lot of the proposals I mentioned. Currently, the House Judiciary and the Senate Judiciary Committees are working on a bipartisan effort, and bicameral, I guess, effort to propose new reform, but we haven't seen it yet, and it doesn't look optimistic that they're going to actually reform the two biggest things that are the problem with it. So like the profit incentive and the innocent owner burden are kind of tinker around the edges with some of the procedural reforms. But there are, even there, like if you want to just cut the profit incentive, you have to go to at least 3 different statutes, because there's the federal Department of Justice Asset Forfeiture Fund. There's also a Treasury Forfeiture Fund, so IRS seizures or other agencies that do seizures. There's over 20 federal agencies that engage in seizures, so it's a mess.
Well, thank you
Anybody
very much
else?
for coming. Thank you so
Well,
much.
thank you so much.